Well, one thing that the position I've always taken is that we want to have open and fair and equal access to the ballot box for all South Carolinians in all communities. But at the same time, we want to ensure that the process of voting has integrity to it, that we protect the integrity of the election process. And I thought that the General Assembly did a fairly decent job of accommodating during this very difficult time with the pandemic and the COVID situation going on. The General Assembly did a very good job of opening up absentee voting for all South Carolinians without any reasons. There are no prohibitions for anybody. You didn't need to fall into an exception. Anybody could vote absentee beginning, I think, today or yesterday. So, I mean, you have 30 days to vote. They considered the removal of the witness signatures, and they declined to do that. I think the Supreme Court recognized in a concurring opinion written by Justice Kavanaugh that the federal district court should not act like a super legislature when determining how states should operate their elections. And so I think the Supreme Court was deferential to the state General Assembly, recognized that it accommodated the citizens in allowing them to vote 30 days out. My parents actually voted today, 30 days out. So I think that the court recognized that. I think it was a good decision. And again, we want to protect the integrity of the elections, but we also want them to remain free and for everyone to have equal opportunity and access to the ballot box. We don't want anyone to feel like that they have to choose between voting and compromising their health. That is the last thing anybody in any party wants to do. But you have to do a balancing test. And the courts have always felt that the General Assemblies of the respective states were in the best place to take into account those issues. And that's what they did in this particular case.